go straight to former Attorney General and Senior Advocate of the Supreme Court, Mukul Rohatgi, who joins us live. Mr. Rohatgi, of course, there's a lot of political debate which is going on with regards to this bill, which is now before the Joint Parliamentary Committee. As a senior advocate, what are your thoughts on this legislation? Do you think it's draconian, as the opposition is saying, or are you of the opinion that the intent with which this bill is being brought in is certainly in the right direction because it is about the cleanup of the political class in general?
See, Maria, my first impression is that the legislation is an attempt to clean up the politics and the politicians of this country. There are large number of cases where, politicians are in jail, and we saw in the case of Delhi that files were being signed in a jail or from a jail cell, etc. Now it is obvious that it is inconceivable that a government can be run from jail, that too by an important minister or a chief minister. So the law is welcome, and the law only says that if a person is in custody for 30 days or more, he will lose his ministership. Well, once he gets bail, he may have a right to come back as a minister should the chief minister want him back. So it's really a temporary kind of a situation. It's not a permanent situation like saying that if you're in custody for more than 30 days, you are damned forever and you can never be an MLA or you can never be a minister. That would be draconian. But this is only a temporary kind of a situation of 30 days or 40 days. There is too much halavaloo about it.
Okay.
And I don't think that, it's like making a mountain out of a molehill.
Okay, Mr. Rohatgi, the opposition says that there have been multiple instances of misuse of agencies, the Enforcement Directorate, the CBI. And if you look at this data, which essentially says that there have been 13 instances of sitting ministers being detained by either the ED or the CBI, and most of them have ended up spending 30 days in jail. So this essentially looks at some kind of legislation which is being brought in to politically target opposition because it gives a lot of power to the executive and perhaps create some kind of anarchy in states to topple governments which have been democratically elected by the people.
See, Maria, possibility of misuse does not make the law invalid. That is settled legal position. Now, if it is found that in some cases the ruling government is trying to put opposition ministers in jail, etc., well, then you have courts, don't you? You can go to court and the court grants you bail. All opposition ministers or MPs or MLAs have got bail. And if I may dare say, once this 30-day rule is there, it would be legitimate to tell the court concerned, which is hearing a bail petition, that ask the court to decide it at the earliest so that the deadline of 30 days is not crossed. I mean, it would in fact help a detainee in trying to get an early hearing as opposed to, the bail taking a few months or 6 months or 8 months. This would be a weapon in his hand to ask the court to look at it at the earliest so that he does not, suffer the guillotine of 30 days. I think that's the silver lining that one must look at.
Of course, the intent here is that the governments should not function out of jail. The administrative functioning should not happen out of jail. But sir, isn't this legislation a bit too harsh? Because the premise has always been that you are innocent until proven guilty, and detention and conviction are two very different things.
I agree with you, Maria, but the problem in our country is that a conviction takes 10 years. And the disqualification to stand in an election is also based on a conviction. So the other end of the spectrum is that it will take 10 or 20 years for a conviction, and then you can otherwise keep on, being in active politics. That is also the other extreme. So you got to find out some media. I mean, I'm sure, one could argue that 30 days would have become 60 days or 90 days. Maybe 90 days would have been more appropriate. But then you've got to draw this line somewhere. And 30 days by itself will not become illegal if the court feels that 60 or 90 is better. You have to draw the line somewhere.
Okay.
And I mean, these are laws which uh, are an attempt to clean up the system. Sometimes they may feel or look a little harsh, but of course, time will tell as in how they are interpreted and how they are put into use. And I mean, it can be changed later also if it is found that it is acting absolutely harshly. Parliament can change it. And also, please remember one thing: the law is there to stay unless it is changed. The current government is there till 2029. Who knows who will come in 2029? And if the opposition comes back and they, try to get their back at the current ruling party,
Okay.
then the members of the ruling party will then face the brunt. No, it's not as if that the current government kind of will remain forever and ever. Governments have a tendency of change. In 5, 10, 15 years, governments change. So it's not as if it's only a one-way traffic. The same thing will come to bite them back. So that's how it is.
Of course, the government, as it presented the bill, it is saying that this is a significant reform aimed at curbing criminalization of politics. And if we were to look at the statement of reason and object, a minister facing serious criminal charges, if arrested and detained, could undermine constitutional morality, principles of good governance, and erode the people's trust vested in him. But will this truly help in tackling the criminalization of politics, Mr. Rohatgi, given the high number of MPs and MLAs we have in the parliament and also in assemblies across the country who have criminal cases against them?
Maria, according to me, having a law saying that only on conviction an MP or an MLA is going to be disqualified, I think that is also too lax, too relaxed or lax a position. Keeping in view, as I told you, that a normal trial may take 5 or 10 years, and then even judgment of conviction can be, in rare circumstances, suspended by the higher court. And then you can jolly well carry on for 10, 20, or 25 years. According to me, keeping in view the long delays in our system and reaching the end of the road of conviction taking so long, maybe one needs to have a look at the election law and find an intermediate point at which the disqualification will occur. It could well be framing of a charge, post a charge sheet by the competent court in an offense punishable with 7 years or more, something like that, so that the taint of the disqualification or the fear of the law comes in. I mean, if you are going to look only at a conviction after 10 years or 15 years, then there is no fear of the law. Everybody in this country violates traffic signals with impunity. But the same person who travels and goes abroad and drives a car in the US, he will dare not, violate a traffic signal because of harsh and swift penalties. Therefore, you need to have the fear of the law. You need to have a relook at the whole system, not only this law which is coming. These are all knee-jerk reactions. Look at revamping the entire criminal justice system, where it can't take 10 years for a trial. I think the debate should be more on the larger issues than only looking at this this aspect of the law.
Okay. Let me sum up this conversation with you, Mr. Rohatgi, with my last question. The opposition is saying that this bill distorts parliamentary democracy. You are of the opinion that there is a need for a larger debate. What are the key aspects, do you think, which should be debated?
According to me, the larger debate, as I said, is revamping the criminal justice system. The government has taken one step in that direction by revamping our criminal laws, procedural and substantive, by trying to bring in Indian notions of justice and criminality and crimes, because we were following 150-year-old British notions of criminality. That is a welcome step, but
Okay.
that step has not really, in my humble opinion, addressed the point that the trials take an interminable long period of time. Our courts are clogged. I see it every day. And the real problem is that the prosecuting agency and the investigative agency is one and the same, namely the police. Imagine a police sub inspector who is investigating a crime, who is also doing police duties, who is also writing a police diary, and he is also looking after the prosecution in the court by going to the prosecution counsel or the lawyer, getting the witnesses and trying to see that they are examined. You can't have three or four roles into one. In many countries, the roles are separate. So you have to start from that. You must have a separate prosecution agency specialized, a separate investigative agency specialized, and a normal police for policing affairs in the city or on the roads. You start with that and then try and tell the court that we are swiftly investigating. I can tell you, Maria, that I am doing cases where investigation is not complete for 10 years, 12 years.
Okay.
If you can't complete investigation in 10, 12 years, you are going to start framing of a charge after 10 years. God knows how many witnesses are available, how many are alive, how many will remember what happened. So, therefore, it's a complete pitfall. You have to start from the beginning, strengthen up, shore up the system, and then only there will be some fear of the law. And then all these laws will fall into place. That's what you have to do.
All right, Mr. Mukul Rohatgi, always a pleasure speaking to you, sir. Thank you for speaking to India Today.